In your view, then, for us to decide the case, we have to start with the premise that we're talking about labor activity on private property.
Respectfully, I would suggest to decide the case, the way I think this holds together is you say Mosconi's unconstitutional, 1138.1 is unconstitutional.
Oh, and that's
while you're at it, you overrule Sears and Lane.
Yes.
Wait a minute.
Now that's asking quite a bit of this court.
And do you want a pony for the holidays too?
Well, say it's true that Sears interpreted Mosconi and upheld it and didn't consider the First Amendment issue, but did reiterate Schwartz, Torrance, and Lane and its validity. But along the lines of what Justice Kennard had said, 1138.1 came into being in 1999, correct? So against this landscape that changed, in comes 1138.1, which provides for, as counsel has indicated, again, courts can't act unless some things are proved during a labor dispute. But I want to go back to say, to get to the, I think, the premise of your argument that the Mosconi Act and 1138.1 are unconstitutional because they favor speech. But when I read those statutes, they're unlike the statutes in Mosley and Carey. They don't directly restrict or inhibit any kind of speech. What those statutes do, and I'm referring to 1138.1 and the Mosconi Act, is it regulates conduct. In the federal cases, when they discuss the Norris-LaGuardia Act, upon which the Act and 1138.1 were modeled, they say that the Act is meant to regulate conduct, particularly court's jurisdiction, but not expressive activity. So what do you say to that finer reading of those two statutes, and that they don't regulate speech?
Well, clearly the court is correct. There is a difference in the language, but I would say to you at the end of the day, the result is the same. It's true that what our two statutes do is limit access to the equity jurisdiction of the Superior Court for injunctive relief. But at the end of the day, what it means is that Ralph's or any other store like it, regardless of where it is, but say particularly assuming it's a standalone store for purposes of this conversation, the stores are free to go into court and on a minimal showing under the standard injunctive procedure, obtain a restraining order saying we have an absolute ban against any kind of corporate
Counsel,
activities.
we have in the labor employment area bundles and bundles of laws that even restrict speech, much less favor it, restrict speech on the basis of content. What about laws against sexual harassment? Are those unconstitutional on your theory?
No, but they
Why? Why are they not
directed
unconstitutional?
at the speaker and at speech that is considered dangerous. It's crying fire in a crowded theater.
It's not fire in a crowded theater. That's not fire in a crowded theater. That's not a clear and present danger to public safety. That's just a preference that there not be certain kinds of harassing speech in the workplace because it furthers a certain conception of workplace policy. I've never understood that to be subject to even First Amendment scrutiny, much less strict scrutiny.
Well, yes, it's a difference in degree, Your Honor. I'd have to concede that as a fire and sexual harassment, but I think
Why isn't this the same? The legislature has a certain conception of what makes for good labor policy to promote all the goals that the legislature says, peaceful labor relations, the proper resolution of disputes, whatever its conception is. And incidental to that is this set of statutes that says we should let these kinds of activities run their course without judicial interference.
Because
this is not even a restriction on speech. I mean, the laws against sexual harassment are restrictions. What about, take a different kind of statute. What about laws against price fixing? Laws against price fixing restrict speech. You can't say certain things when you're with certain people under a law against price fixing. No one would call that a restriction on speech subject to First Amendment scrutiny. That's a regulation of economic conduct.
If I were a plaintiff's class action lawyer, I'd be making notes now. I think, Your Honor, that you're identifying a number of laws that could be subject to
What about the
this
secondary
case.
boycott cases? The secondary boycott cases. Are laws against secondary boycotts permissible? I mean, those have been upheld.
They have been upheld.
I mean, that's pretty
so-
remarkable as a precedent against your theory, don't you think?
No, I don't, because you can have a secondary boycott that doesn't involve labor speech. Well, you held in Fashion Valley that boycott, to a rule prohibiting all boycotts is content discrimination and impermissible on that basis. So I see your point. But you can have a boycott that has nothing to do with labor speech. If a customer buys a product at a store and it's defective, and instead of boycotting the product, boycotts a whole chain of stores. But I know I have a very little time, and I don't know. The simple answer to your question is the United States Supreme Court.
That seems like that can't really be right, can it? The property rights under the Fifth Amendment? I mean, Rouse, I'm sure, is subject to all manner of employment law, environmental law, all of which interfere with what it may perceive to be its efficient operation. Are those all subject to this balancing of constitutional property rights as against the legislative prerogative?
I think first of all, I think there's a difference when there's a safety issue like environmental law. Second, there's none of the laws that you've identified, Your Honor, that I think interfere with our ability to conduct our business. They may cost us money.
That in and of itself is an interference, is it not? I mean, we hear that argument quite frequently.
Yes, but you've also said that that's not enough.
But the gist of that, but this too is costing Ralph's money in a certain sense, right? I mean, the point is that we typically evaluate those regulations for Fifth Amendment purposes. We just ask whether those regulations are reasonable. We don't subject them to any kind of higher degree of scrutiny. In other words, the notion of constitutional property rights being a shield against general economic regulation, I thought was a notion discarded long ago.
I think in some respects it has been, Your Honor. I think in the context of using the property for which the business owner intends still carries with it a bag full of rights that have to be balanced against the rights of other groups, whether it's union groups or
But isn't
others.
it, counsel, still a balancing act? We said so in Lane. It was and Sears was a private parking lot, and still, at least in Schwartz Torrance, which was a shopping mall, the right of unions to express activity by way of picketing was balanced with the property interests of the owner. And it is in that balancing, it seems to me, I think I understand you saying, that may be where time, place, and manner regulations may suffice. But it's still a balancing, and in that balance, as I think counsel alluded to on the other side, labor speech has statutory protections in California law that balances the other side of the property rights of the owner.
Yes, Your Honor. Aside from the fact that I happen to think Lane was wrongly decided, I am beating a dead horse. I'm starting to realize that. It was, again, union activity. It was labor activity. And the other major part of my argument today is that Lane is wrongly decided because it gave special treatment to the union and did the balancing it did because it was labor activity. The same is true with Schwartz Torrance. The same is true with Sears. There is no case coming out of this court that extends access rights outside of a large shopping center that doesn't involve labor activity.
Well, Ms. Vogel,